Good morning to all of our attendees and welcome to the first NBC Legal Webinar for the year. My name is Nicole Makoloko and I will be your facilitator for this session. So to start things off this morning, what we'd like to do is pose a question to all of our attendees. So the question that we want to pose to you, we're actually going to do a poll. And we would love for everyone to actually engage with the poll and provide us with your feedback. Is your vote yes or no? So the poll question for today is going to be, do you think that the seeding capital that is currently calculated at 10% or 30,000 Rand maximum of your vested pot as of 1 September is actually going to be enough for our members? So please do let us know what you think. Do click on your screen, let us know, do you say yes or no? And if your answer is no, we'd also love to hear your feedback, and you can use the chat box to let us know why do you think that this amount is actually not enough. So while we let everyone cast their votes, I'm going to just quickly go through some quick housekeeping rules to make sure that we have a smooth and enjoyable experience for all of you as our attendees. So firstly, if you have any questions during the webinar, please do feel free to utilize that chat box. Our team will be monitoring it closely, and we will do our best to address all the queries and to ensure that either during the presentation or during the designated Q&A section, time permitting, that we actually address all of the questions that are posed. Secondly, please, this one's also very important. Please remember that this is a CPD accredited session and your CPD certificate will be downloadable after the event. So please do download your CPD certificate after the event, and that's when you will get your event accreditation. Then next up, if you have any technical difficulties during the webinar, please reach out to us as well. You can either email us at nbcwebinar@nbc.co.za, or you can put it in the chat box. We'll also be looking at that quite closely again, and we'll see if we can address any technical queries that any of our attendees might be having. So lastly, the slides for all the presentations, as well as a recording link, are going to be made available to all of the attendees. All you have to do is email that NBC webinar at nbc.co.za in order to get a hold of them. And if you're unable to do that, you can also email one of the presenters to give you access to the link and the slides as well. So I think we have the votes that have been casted for the poll. If we can have them up on the screen. Let's see what we have here. So we have a resounding yes. Quite a few people believe that this maximum amount of 10% or 30,000 Rand is actually going to be enough. As I said before, please do let us know whether it's a yes or no, why you think that this amount is going to actually be enough for members who might be wanting to actually take from their savings pot come the 1st of September 2024. So with that said, once again, thanks again for joining in with us today. We hope you find this webinar both innovative and engaging. And if you have any further questions, as I said, do engage with the chat box. So for our first session, I will introduce Tony Billing and Giabeto Matai, who will be joining me in talking you through the latest update regarding not only just rule amendments, regarding two-pot system, and also the impact that the two-pot system will have on particularly Section 37D of the current Pension Funds Act. So Tony and Kia.
Hello, everybody.
Morning, everyone.
Good morning. Thank you for joining me. So before we start off, I would like to take a few steps back. So maybe for some attendees who might not remember, I'm just going to give you a brief scope on what two pots is about and the legislation surrounding it. And that's what our discussion is going to be based on today. So firstly, we're looking at just the aim of what's called the Pension Funds Amendment Bill. So this bill is actually being used to bolster and safeguard the members' pension interest. And that's because many individuals in formal employment currently contribute to their retirement savings throughout their lives, and they make it a pivotal source of their savings. So these amendments that are coming into power are going to be intended to fortify the protection of their pension interests. And then it will also be in line with what the pension funds adjudicator is meant to do. So it's just all about protecting the members' pension interests. So the objectives of the bill, as per the bill, is to firstly safeguard the members' pension interests. And then secondly, it's also to adjust the current act and accommodate the shifts to the regulatory policies that are coming into place, as well as address the practical implications that need to be looked at. So our first question will be about the rule amendments, and this one I'll address to Tony. So Tony, firstly, based on the recent communication from the Financial Sector Conduct Authority, they issued a communication called Communication 3 of 2024. Can you maybe walk us through what that communication is about, and in terms of your speciality, what you deal with in terms of that?
With pleasure, Nicole. Thank you. As you rightly said, FSCA issued a communication to give us some guidance on what they're expecting in our amendments. But before I go into that, I must just let the delegates know that we have liaised with FSCA directly, and they have agreed to have a look at a template for the changes to our various funds. And once they have approved the template, then we will be able to refine it to fit the rules for each individual fund. And then we can distribute, we can get the signatures, and they have agreed that from July, they will accept these amendments. Before then, we will be submitting from the 1st of May. They will be accepting our drafts, and they have actually employed some interns who they will be training in order to expedite the whole registration and approval process. So I just wanted to put our delegates' minds at ease that NBC is actually fully prepared when it comes to the rule amendments. Then I also wanted to highlight that FSCA have now changed the wording. So we no longer refer to two pots, we now refer to two components. So if our delegates see that in their amendments, at least they're aware of where this comes from. Essentially, we will still keep our definitions and our provisions that we had when the annuitization came into play, and that would be the vested and the non-vested benefits that we've defined in our rules. Nothing much will change with those particular benefits. They will continue to be dealt with as they were in the past, as they are currently, and then going forward, we will then implement the two pot or two components changes.
Thank you for that. And then I think in that communication, there's also mentions of the seeding capital savings component. Could you maybe just give us what you got from that communication as well for all of our attendees?
Thank you, Nicole. I did some training recently, and the one thing I noticed is that there appears to be a little bit of confusion. Members seem to be of the view that they will automatically have 30,000 Rand available in terms of the seeding capital. And I just wanted to make it clear that in actual fact, that amount isn't a given. The amount will be 10% of whatever their current benefit is in the fund. That's both vested and non-vested benefits. So the balance will then, they will put a 10% percentage of that into the savings component. So if that 10% is in actual fact less than 30,000, then that is the amount that will go into the pot. If the amount is more than 30,000, if that 10% is more than 30,000, then they will limit it to 30,000 in that savings pot. There are also a couple of entities that are excluded from the two-pot arrangement, and those are unclaimed benefit fund members, pensioners, beneficiary fund members, and members who exited service before the 1st of September, who have completed and submitted election forms. Also, non-contributing members of terminating or liquidating funds. They will also be excluded from the two-pot arrangement. And obviously your members, like myself, who were older than 55 on the 1st of March 2021, we will be excluded from the two-pot arrangement unless we opt in to that particular arrangement. I think also we should highlight the fact that the savings component will also be taxed very, very highly at the marginal rate, and we need to make our members aware of the effect that this will have on their ultimate retirement benefit.
So, Tony, I think you touched on a very important point there, being taxed on the marginal rate. A lot of questions we've gotten is many people don't understand what is the marginal tax rate. What does that mean for members?
Okay, that would equate to the pay-as-you-earn tables that they're currently paying on their salaries. So your salary is obviously going to put you into a specific tax bracket. And then regardless of the amount that you then withdraw from your savings, you are going to be taxed at that particular tax rate. Okay. Whereas with retirement, with retirement, you obviously get the tax benefits of your 550,000 Rand.
And I think this one is going to be quite important to communicate, as will many of the nuances regarding the two components system. And I think Gia is also going to touch on the importance of communications to members, especially regarding these kind of intricate things that no one's really talking about. Everyone's just excited about, we get to access our money. And as you said, they are misguided in terms of understanding how much is actually going to be available and for how long and for which members specifically. So I think that one we're going to have to make sure, and we know that at NBC we're going to be communicating quite heavily, not only through these legal webinars, but also providing that kind of information to all of our members as well through online portal systems, etc., and providing that intense communication to all of our members. So thank you so much, Tony, for that rundown regarding that communication. I think it was quite recent and a lot of people might not be aware of it as yet. So now I'll move on to Giabete, who's going to take us through the first part of the two-part system, or the two components system, and how it will be actually affecting Section 37D of the Pension Funds Act. Gia will be taking us through sections 1 to 3, and then I'll also be touching on sections 3 and 4, or rather subsections 3 and 4 of the Section 37D component. So Gia, please, can you start us off?
Thank you, Nicole. So as Nicole has highlighted, the purpose of this presentation is to highlight the proposed amendments to Section 37D of the Pension Funds Act, in line with the introduction of the two-part legislation, that being the Revenue Laws Amendment Bill, which now refers, as Tony has highlighted, that the implementation date is now the 1st of September 2024. We are yet to see the final bill, and which this will definitely have a bearing on the retirement funds readiness. We also await the Income Tax Act as amended, which is the first step towards implementing the necessary changes with regards to system changes. We also await the final Pension Funds Amendment Bill, which is necessary for private sector retirement funds to give effect to the two-part retirement system. And other acts applicable to would be the Government Employees Pension Law, which is applicable to the public sector retirement funds. So as Nicole and Tony have said, NBC has taken proactive steps to ensure that we will be ready come 1 September 2024. So as a general rule, pension benefits are not reducible, they're not transferable or executable, but there are exceptions, and these exceptions are outlined in Section 37D of the Pension Funds Act. So it provides a list of instances where a fund is allowed or permitted to make deductions from a member's pension benefit. So the Pension Funds Amendment Bill proposes the substitution of the Section 37D of the Pension Funds Act to enable retirement funds to make deductions from the benefits in line with provisions and the requirements as set out in the Revenue Laws Amendment Bill. The Pension Funds Amendment Bill also specifies or rather outlines conditions under which a member may make or rather take savings withdrawal benefits, and it also outlines restrictions for funds who are aware of orders that have been made against members. So the key communication to members here would be that deductions from the member's benefit permitted in terms of Section 37D of the Pension Funds Act will be made proportionally across all the three components, that being the savings, retirement, and vested component. And I guess another highlight that we would have to make to members is that in order for this to happen, the fund rules will have to make provisions for this. And as Tony has highlighted, funds may submit the rule amendments as we speak. They just need to ensure that they do that before the 1st of September 2024. So essentially, by allowing Section 37D deductions to be made proportionally across all the components has an impact on the access of the funds in the savings component. But the National Treasury has stated that there is a protection around the savings component, and this is done by permitting access to the savings pot unless it depletes that component. So the message here would be that there is an express need by the National Treasury to balance members' access to their savings component and their financial obligations as well. So now I'll be taking you through the following allowable deductions that will impact members' savings component withdrawals, namely the income tax, outstanding home loans, compensation, and my colleague Nicole will take you through the remaining deductions, which would be the Divorce Act, or rather divorce orders. So with regards to income tax, when a fund receives a claim form for a savings withdrawal, the administrator will apply for tax and deduct the marginal tax before payment is made to the member. So this means that if a member has unresolved tax issues with the South African Revenue Services, SARS that is, the member will not receive a benefit until that matter is resolved. In other words, any amount due by the member in terms of the Income Tax Act will be deducted before the member is paid his benefit. As mentioned previously, we still await the amended income tax, and in the absence of this regulation, it may result in the discretion of each fund to decide on how they adjust the benefit. Therefore, it would be useful for us to have sight of the directive, meaning to say that it would be useful for SARS to publish the directive so that there wouldn't be any delays experienced by members when they do withdraw from the savings pot. So the key communications here for members would be that if a member withdraws from their savings component, it will be taxed through the marginal tax rate, and funds administrators will pay tax to SARS, and the member will be paid the after-tax amount. Therefore, members need to be aware that funds are likely to apply for withholding tax, which may result in them having a secondary tax liability if the tax directives are not published by 1 September 2024. So in relation to outstanding home loans, currently if a member has an outstanding home loan, the fund will settle the housing loan before a payment of a withdrawal benefit can be made to members. Where the fund rules allow for housing loans or guarantees provided by the fund or any amount due to the fund in respect of a housing loan or a guarantee, that will be deducted. So the one thing that I'd like to highlight is that currently that deduction will be made from the benefit that the member or beneficiary becomes entitled to in terms of the rules of the fund. Or in the case of the member defaulting on the repayment of the loan, the amount of the benefit which the member would have received on termination of the membership, and as well as on the date of that default. Where the fund rules allow for housing loans or guarantees provided by the employer, that too housing loan amounts or the guarantees will be deducted from the member's benefit. This deduction is limited to what may be taken as a lump sum payment by the member. So currently, the proposed amendments under home loans are that they will be capped to 65% of the member's individual account or the minimum individual reserve in the member's interest in the savings, retirement, and vested component. The draft bill currently states that Section 37D loan or guarantee will be deducted from the amount which the member would have received on the termination of membership. The member will only have access to his vested component and his savings component on termination. That is to say, he will not have access to his retirement component. So based on this proposed wording, or rather proposed changes, it's unclear if the loan or guarantee will be deducted proportionally across all three components. And if this is not made clear, it could result that the deductions of the loans and guarantees could be made against only the vested component and the savings component, resulting in a substantial reduction of the funds in the savings component, and thus limiting the members' access to their savings component. But nevertheless, the proposed amendments permits a member to take savings withdrawals where a loan or guarantee has been furnished by an employer. But members need to be aware of the fact that the funds will take account of risk and liquidity perspective, and members' behavior as well in light of that flexibility presented to them with this proposed amendment. But with the absence of the savings withdrawal restriction, funds may opt to amend their rules to allow funds to establish liquidity before processing a member's withdrawal claim in case it might pose any threat or risk for the fund to process that claim. And now for compensation. Compensation to the employer in the instance where the member has caused damage to an employer as a result of perhaps theft, fraud, or dishonesty. The member should have admitted to that fraud, or rather causing that damage to the employer as a result of the fraud or theft. And in the case that the member has refused to sign an admission of liability, the member should at that point then obtain an order. And that order should be in respect of the damages caused. So according to the proposed changes in the Section 37D, members will be permitted to take a savings withdrawal where there is a judgment in favor of the employer that has not yet been executed. So this poses a practical challenge in that most administrators are preparing to be able to process bulk savings withdrawal claims based on online applications. And it would pose a potential delay in that funds will not necessarily be aware of the housing loans, so they would have to take that necessary steps ensuring that they are aware of the housing loans and the amounts that are related to them. Nicole, would you like to take us through the details of the Section 37D deductions for the housing loans?
I would love to, but just before we get into the last few subsections, and those subsections relate to the maintenance orders and divorce orders, Tony, I think what Gia has mentioned is quite important. Is there anything you'd like to add or highlight in terms of what we're talking about thus far?
Nicole, one of the things I wanted to just make quite clear is that in the training I did as well, it seems that certain members are under the impression that the seeding capital is a consistent arrangement. And I think it just needs to be made clear that it's a once-off, and that you may transfer from your savings to your retirement components, but a reversal of that it isn't possible. And then I also wanted to, on the rule amendment side, just mention that we've had it clarified by FSCA that they won't accept any other changes in the amendment except the two-pot changes. And the reason for this, as I mentioned, is that they want to approve the template that we have for those specific changes, train their staff accordingly, and then their mission then is to register these amendments as quickly as possible. So I think that is something important. And then I also wanted to highlight that there is a possibility that funds may get exemption from, not exemption, extensions to the deadline. Obviously, whatever happens in that space needs to be adequately communicated to members. And the FSCA is quite strict in terms of the communication. They want it to be in line with treating customers fairly, and it needs to be obviously simple, clear, comprehensive, timely, etc. There needs to be ongoing communication, and they may actually ask for copies of this communication. The rules also, as we were speaking about the 37D deductions, they will need to go into some detail, whereas before our rules in this space were fairly generic because they relied on the Pension Funds Act's provisions. But it's a little bit of a quandary we're in, because as Kia was saying, it is a bill. So to bring in these provisions into our two-pot amendment may be a challenge if we don't have the promulgation before we submit amendments. And I also wanted to mention that transfers between the pots will be tax neutral. So it's seen as just I would imagine like an accounting arrangement with no tax charges levied against the transfer. I think that sort of covers what I wanted to add to Kia's presentation.
Yeah, I think those are quite important points, Tony. I know that I've engaged in some conversations and some feedback with regards to these rule amendments and possibly adding other rule amendments within the two-part amendments, especially since it's going to be, prioritized, where we've had to kind of tell clients, etc., that that's not going to be a possibility. So the two-part amendment or the rule amendments, they cannot have any other rule amendments involved. It's going to be very strict. There's no way we're going to be able to sneak in any other rule amendments that might have been delayed. There's no sneaking on this one.
No sneaking.
It has to be straightforward about the two parts rule amendment. So just thank you for highlighting that point as well.
Nicole, sorry to interrupt you. Something occurred to me. One of the questions that was posed during the training was, what if a fund has amendments that are pending? And the normal FSCA route is that it must be in a numerical order. So they will only register Amendment 7 once Amendment 6 is registered. So I haven't been given an affirmative, but the understanding is that these two-part amendments will be prioritized ahead of any possible pending amendments. Thank you, Nicole.
Yes. So that's also something else to take into consideration, because we know that we do have funds that have rules that are currently pending. So most likely the two-part amendment rules will be put ahead of actually the current rules that are pending. So just thank you for that one again, Tony. So now we're just going to go back into what I will be discussing in terms of how two parts is going to affect the 37C deductions. Just a reminder to all of our attendees that these deductions relate to what a fund can deduct from a member's fund credit, what is permissible. So we know that the Act doesn't allow for any seeding or any deductions to be made except in these specific situations. So Kia has mentioned quite a few of them. And then I'm going to just quickly round off. I'm just looking at time. We have quite a few speakers. So I'm just going to round off regarding maintenance orders and divorce orders. So a reminder again, 37D, actually what it does, it prioritizes and creates sort of like a hierarchy of which deductions are most important first. So obviously the first one would be that of tax, and then there would be the housing loans. And then what I will be discussing is the next one, which is the maintenance orders. And then the last permissible deduction is the divorce orders. So we know when firstly, when a member perhaps hasn't been paying their maintenance or that they were supposed to pay, what happens is a court can grant an order and obligate a fund to actually make payment of the arrear maintenance of that member from the fund credits. And then the next situation will be where a member is actually going through a divorce proceedings, and we as the fund or administrators receive this divorce decree. Provided that the wording is valid and accurate, what happens is that member can have a portion of their fund credit actually deducted, which we call pension interest. So I'm just quickly going to go through what the bill proposes the new wording will be, which is firstly, in terms of the maintenance orders and the divorce orders, the bill now will state that there's no new loans or guarantees that are going to be given, and there will also be new savings withdrawals benefits paid if a fund has actually been advised that there are divorce proceedings that have been instituted, or if there's actually an application for a divorce splitting court order, and that if that court order has actually been made. And this is obviously under the presumption that the fund would have been informed of these proceedings, and thus the fund will, quote unquote, let's say, freeze this benefit and wait until the court order is actually applied and supplied to the fund. The next one is going to relate to the payments in terms of maintenance orders. What happens here is that arrear amounts can be settled as a lump sum, but the ongoing payments, so that future maintenance that court orders might want to, courts might want to implement, will have to be made monthly or yearly. And obviously this, even right now, currently is quite impractical for a fund. So that wording also, we are trying to look into ensuring that a fund is not burdened with the payments of any kind of future maintenance. So now what the bill also specifies in the new wording is that a fund may not allow a savings withdrawal benefit where there is a maintenance order in place unless the fund is satisfied that paying the benefit will not leave insufficient value remaining to cover the maintenance payments. So that means that even if a member wants to withdraw from their savings pot, if they don't have enough to cover that maintenance order that's pending, then the maintenance order is going to take precedence over your withdrawal for your savings. So that's also something that needs to be communicated to members as well. And then the next thing that I'd like to discuss is just what the new bill is saying is that a fund may suspend a savings withdrawal if a fund is aware that proceedings relating to a maintenance order are pending, and if paying the benefit would leave insufficient value to cover the possible maintenance payments. And that's just a different version of previously. The first portion says where there is an order, the savings payment will be withheld. Whereas here it's saying, even if there's no order as yet, but if the fund becomes aware of proceedings that are actually taking place, that the savings component of fund actually has the discretion to now suspend that payment until the final order is received, if they view that the payment to a member of their savings component will result in the maintenance order not being able to be fulfilled. And then the last point to wrap up is going to be dealing with the wording in terms of now how we're going to deal with divorce orders. So the wording now says it deals now in detail with the divorce splitting procedure, and it's now somewhat rewritten. So it's not that much different. It's just sort of rephrased. And the most significant change is that this provision will now entitle the ex-spouse to a fund return. So this must be specified, obviously, on the court order from the date of the court order. So that's an additional one where the spouses, the former spouse, or we call them the non-member spouse, will now be entitled to the fund returns as at the date of the court order, or rather from the date of the court order as well, rather than the date on which the specified amount was deducted from the member's benefit, which was going to be following the ex-spouse's election. So that's also quite an important change that was noted in terms of these last few sections regarding just the maintenance and the divorce orders. And I think just for the sake of time, I'm going to cut it there. And I am now going to thank everyone on this panel. Thank you so much for joining me. And we will be presenting our next presenter, which is going to be Carla Skuman. And she's also going to be focusing on what we are focusing all on today, which is going to be another aspect of how the two-part system is affecting our industry. Thank you.
Good morning. Thank you, Nicole. And thank you to all the delegates this morning for the opportunity to speak to you. As Nicole mentioned, that I'm also going to be talking about a two-part aspect. I think that all of us are a little bit two-part fatigued at the moment. So I'm giving us a slight break. This morning, I will be discussing the recent developments that came from the Office of the Pension Funds Adjudicator's Office regarding her jurisdiction when it comes to divorce and maintenance orders. So usually in the past, she did determine on whether maintenance and divorce orders were in fact enforceable against the fund. However, very recently, during her latest newsletter, or rather during April last year, they issued an article that changed, or that published the changed view on their jurisdiction. And it summarizes that they do no longer have jurisdiction to adjudicate these kind of disputes, specifically with regards to the enforceability of divorce orders as well as maintenance orders. And that is based on two reasons, and I will unpack both reasons during my presentation. So firstly, the office's argument is that it doesn't fall within the ambit of the definition of complaint as per Section 1 of the Pension Funds Act. And secondly, she does not have jurisdiction because it's already a dispute that's lodged in a civil court. So let's look at what is the definition of a complaint as defined in the Act. So it's a complaint of a complainant relating to the administration of a fund, the investment of its funds, or the interpretation and application of its rules, and alleging that either the fund acted outside of its powers, that there's maladministration, there's a dispute of fact or law between the fund and any person or the complainant, or lastly, if an employer who participates in the fund has not fulfilled its duties in terms of the rules. So that is, for example, non-payment of contributions and so on. So in essence, a complaint to fall within the definition has to be against the fund for its administration, maladministration, the investment of its funds, and the interpretation and application of its rules. So the adjudicator argues that disputes about the enforceability of divorce orders neither falls within neither of those categories. A divorce order's enforceability is not the administration, it's not investment of fund assets or interpretation of the fund's rule. And so it was during the course of last year, I also had a claim in the Tlihani versus the NURF that dealt with the enforceability of future maintenance claims. So we used to rely on a determination, the Meraki case, that was issued by her office, which said that, future maintenance orders are not enforceable against the fund. Then we received an out of jurisdiction letter. She did not determine this future maintenance claim. She stated that it no longer falls within her jurisdiction. In this case, she argued that the matter didn't qualify as a complaint as per the definition, and that Section 30H2 of the PFA excluded her jurisdiction because the matter had been subject to civil litigation in another court. So, yes, the issue was already determined by the maintenance court. There's already a decision, and therefore she cannot adjudicate, and it's out of her jurisdiction. So it's safe to deduce that any time of court order that is subject to a dispute lodged with the OPFA will receive similar treatment. That she is likely to rule that her office does not have jurisdiction, either because the dispute is not a complaint as defined, or relying on Section 30H2 of the PFA. And we've seen a few financial services tribunal rulings in support of this view. There is quite a few unintended consequences of this change in view or approach by the OPFA. So we know we as a retirement fund or an administrator of a fund do on a continuous basis receive a lot of decrees of divorces to be vetted, either if it's enforceable or not enforceable against the fund. So just to recap that, for a divorce order to be enforceable against the fund, there's a few requirements that has to be met. It has to refer to pension interest because there's a very specific definition regarding pension, what exactly pension interest is. Then the percentage must be clear. The fund must be identified or identifiable in the order. The fund must be ordered to make payment to the non-member spouse and to endorse its records. So those are the 5 requirements that has to be met. If those requirements are not met, the fund cannot enforce the order and cannot pay. So where we receive such defective orders, we usually would inform the parties about the non-enforceability of it. Then they had to approach the court for a variation order to amend the order to that specific wording for the fund to enforce it. Or if they are not in agreement with our view and reasoning as to why the order is not enforceable against the fund, we would refer them to the OPFA to rule on the enforceability. So the dilemma is, as a retirement fund, we do not have a direct interest in the subject matter. So we as a pension fund or the administrator, we don't have a direct interest in the divorce order, in the settlement agreement, in the settlement arrangements. Neither do we have a direct interest when it comes to the payment of rear or future maintenance. And we all know Section 37A dictates that a member's retirement savings are sacrosanct. This means that deductions from members' benefits are so strictly regulated in terms of Section 37D of the Pension Funds Act. If a retirement fund through its administrator authorizes deductions from a member's retirement savings in instances where such a deduction does not comply with the relevant legislation, the fund is at risk for legal accountability. because it will be contravening the provisions of Section 7C that deals with fiduciary duties of the Board of Trustees, as well as Section 37A, which states that they cannot be reduced or ceded. So I touched on it earlier. The practice that was adopted by the administrators on behalf of the funds is wherever they are faced with a request to make a payment that does not comply with it in terms of an order that does not comply with the provisions of the Pension Funds Act, we will inform the parties that and advise them as to the correct wording. And then they can apply to the court for a rescission or a variation order. Or usually we refer the aggrieved parties to go to the adjudicator to make a final ruling if they still dispute the fund's view. So we do agree with the OPFA's view that it doesn't have jurisdiction to adjudicate disputes. Okay, so if the adjudicator's view is correct, we will be facing the following issues. So the retirement fund can appoint attorneys to then make a rescission to rescind these court orders. But the problem is the fund does not have a direct interest. So which means is the fund does not have locus standi to approach the court. Then also the retirement fund will then incur legal costs, and this cost will then be recovered from the fund's assets to the detriment of the other members. Alternatively, the fund can instruct its administrator to give effect to this defective order. However, remember, Section 7C2 of the Act places an obligation of the board to take all reasonable steps to ensure that the interests of the members in terms of the rules and the Act are protected at all times. So a retirement fund that authorizes an unlawful deduction will face legal liability towards the prejudiced member for contravening the provisions of the Act. So we agree with her view that a complaint must deal with the three parts that we touched on: administration, investment, or the interpretation of the rules. But we don't agree that complaints in this category does not fall within the administration of the fund, because funds enters into administration agreements with the administrator on service levels. And some of those service levels also covers the fund to vet various type of court orders for their legal enforceability in terms of provisions of the Act. So when an administrator vets these orders and deems them to be unenforceable, then surely the aggrieved party's complaint is based on the administration of the fund. So the OPFA's view is that the term administration is not defined in the Act. However, Section 37B1 provides that administration relates to the receipt of contributions or the disposition of benefits only. It does not extend to the enforcement of court orders. So there's where we differ in our view. Deductions from a member's retirement savings are done in terms of enabling provisions in the fund's rules. So therefore, on the second point, we argue that it falls within the definition of complaint because it relates to the interpretation and application of the fund's rules. So in summary, on the first point is, like I mentioned, that these complaints about the enforceability of a court order against a pension fund organization indeed deals with the administration of the fund as well as the interpretation of the fund's rules. Then the second part of her argument that Section 30H2 excludes her jurisdiction because it's based on a civil proceeding predating the complaint. So we do agree that this section of the Act does indeed exclude her jurisdiction to adjudicate on any complaint that was lodged after civil litigation about the same issues have been instituted between the parties previously. So put differently, where the member has already approached another court or maintenance court, divorce court for relief in his or her pension dispute, then the adjudicator is precluded from dealing with the matter, like we saw in the Tlihani matter versus NURF. However, the Supreme Court of Appeal, as well as the OPFA, previously laid down specific requirements to exclude the OPFA's jurisdiction, and they are the following. Firstly, proceedings must have been instituted in another civil court. The proceedings must have been instituted before the lodging of the complaint. And lastly, the proceedings must be in respect of a matter which constitute it's the same issues. So the complaint and the facts before the court should be relating to the same set of facts. And we respectfully submit that since retirement funds never have a direct interest in disputes about its members' divorce orders or maintenance orders, there's never a factual dispute between the retirement fund and a complaint about the factual events. So, in essence, when the parties went to the divorce court, the issues were the division of the joint estate and the dissolution of the union. Now, we argue that it's a different set of issues, because now it's no longer about the dissolution of the marriage, it deals with the enforceability of the court order. Same when it comes to maintenance. When they initially approached, the respondent was in arrears with in not complying with initial maintenance obligations. Now, the fund has to decide, or the issues in dispute are whether or not this maintenance order is enforceable against the fund or not. Okay, that is what I mentioned. So the adjudicator always dealt with legal disputes about the enforceability of various court orders. The definition of complaint in the Pension Fund Act did not change, nor has the provisions of Section 30H2 of the Pension Funds Act. Complaints about the enforceability of court orders against pension fund organizations do in fact deal with both issues. Does deal with the administration of the fund as well as the interpretation of the rules of the fund. So we feel that such disputes fall squarely within the ambit of the definition of a complaint. And secondly, we stated that we feel because there's a clear distinct in the factual disputes that was in the initial divorce and maintenance court versus what is in front of the fund now, therefore, the office cannot rely on Section 30H2 of the Pension Funds Act to preclude her from determining these matters. So this new view places fund organizations in a very difficult situation for the following two reasons. Parties claiming payment from a retirement fund in terms of a court order does not have to take heed of any of the retirement fund's valid objections. So they can merely proceed and say the fund is in contempt of court. They are not giving effect to this valid or issued court order, and then they can proceed with the writ of execution against the fund or institute contempt of court proceedings against the fund. This will force the fund to incur legal costs at the expense of the other fund members. in proceedings where they don't have legal standi because they don't have a direct interest in the outcome of the proceedings. And also then, in the alternate, if the fund then decides to avoid the aforementioned legal implications, they don't want to get a writ issued against them or to be found guilty in the contempt of court proceedings, they can and proceed to authorize payment of the irregular court order. The member affected by such irregular deduction of his or her benefit can hold the fund liable for his or her financial loss occasioned by the trustee's failure to comply with their statutory obligation in terms of Section 37C and 37A of the Pension Funds Act. And that is me. Thank you very much, Nicole. To the delegates, you are more than welcome to populate any questions you might have into the chat section. And if time permits, we will see if we can address them all. Thank you very much for the opportunity.
Thank you so much, Carla, for that. I know that was quite a detailed, quite legal, and quite complex topic for people to understand. So we hope that you guys grasped it. And obviously, as I said earlier, thank you to Carla. The slides will be made available at a later stage so that you can really get to grips with the topic. So moving on quite swiftly to our next speaker, it is going to be Mr. Lieb van Zyl, who is going to be talking about the intersection between labor law and pension law. Thank you, Lieb. Hi, Lieb, you're on mute.
Wow. Good morning, delegates. I have to repeat all of that. Apologies for that. So my topic for today is going to be the intersection between labor law and pension law. But before I do that, I would like to make a few general observations about the two pots that we already addressed. And my observation is simply the following. So you will remember that at least the three previous legal seminars that we presented to our clients, the two pots reforms were first and foremost, in all of our presentations. And the message that we communicated was mostly one of uncertainty. We weren't certain whether things were going to proceed due to the lack of legislation coming out on time, due to the fact that there were material problems with the legislation up to that point. That has now changed, and I want to share my observation with you that we need to get ready. I have noticed, and our panel discussed with you, that everything started clicking in place. There was a big uncertainty about SARS. There was a big uncertainty about the FSCA and their ability to register all the rule amendments in time. That uncertainty is now behind us. As things click into place, we will be preparing with vigor and energy so that we are ready to implement the system from 1 September this year. It is not a perfect system. That is not what I'm saying, but we'll need to navigate our way around these problems. And therefore, I want to extend at these early stages already that you attend our June 2024 legal seminar, where we will be unpacking a lot of these changes in perhaps a bit more nuts and bolts and practical manner as we become wiser as to how we need to implement the two-pot system. We have a great idea. We at NBC will be ready, but we do need all our stakeholders, employers, trustees, unions who represent members to be on board, and communication is going to be key. With that being said, I'm going to jump into my topic for today, and that is the intersection between labor law and pension law. And in order to discuss it with you, and I also need to say that given the fact that our main focus for now is on two-pots implementation, because it will change our industry in a radical manner, I'm not going to spend too long on this topic, but it is something that becomes relevant that I will highlight when I refer to the relevant cases. So I'll be looking at constitutional imperatives. You know, when we sit here and we administer members' benefits and we compile answers to queries, we forget that people's retirement fund membership and their employment is actually based on constitutional values. And I'll speak just briefly about the principle of subsidiarity as well when we get to the third point. Then we'll quickly examine what do we mean when we say the employer's pension promise. We look at how we deliver the employer's pension promise to the employees. We look at how the pension law has developed over the recent few years. And then the fifth bullet point there is competing jurisdiction and the principle of subsidiarity. And I'll be referring lastly to a few interesting case law examples. So when we look at the constitutional imperatives that I want to talk about that are at play when we look at the intersection between labor law and employment law, we must first and foremost acknowledge that employment plays a very crucial role in the social and economic lives of the South African citizens. Okay? I think in South Africa, it's perhaps even emphasized more by the fact that we have such high unemployment, and the juxtaposition between people who are employed and people who are not employed, and what a difference it makes in people's everyday lives. So for us, it's not necessarily in South Africa the difference between the haves and the have-nots. That problem is there too. We do have inequality. But for us, the distinction is actually a bit more principle in nature, in the sense that there's a massive difference between people who have jobs versus people who do not have jobs. Now, when we just look at employment in isolation, we see that Section 23 of the Constitution says that everybody has the right to fair labor practices. Section 26 and 27, and to a certain extent also Section 25 of the Constitution, equally provides that all citizens in South Africa will have access to social security. Section 25, for instance, says that all citizens have the right not to have their property taken away or deprived of their property rights arbitrarily. Okay? Now, when we look at social security, we look at things like SASSA, we look at things like public health care, we look at things like the road accident fund, we look at things like the unemployment insurance fund, and importantly for us who are here today, we are looking at people's membership of a retirement fund, because that forms part and parcel and probably the starting point for any employed person and his or her social security. And just to put it in context, you remember when the annuitization of provident funds were debated at Parliament, organised labour has always said that we are willing to accede to the request to annuitize our provident funds, provided that social security as a whole is being addressed. And now it makes sense there. Because here is a practical example. When we retire in South Africa, the likelihood of us becoming dependent on a public health sector is much bigger than a person who lives in Europe, for argument's sake. And I don't want you to interpret this politically. This is our reality. I don't want this to sound political at all. But if you have to make provision for your healthcare after retirement out of your meager income after retirement, it makes a significant difference when you compare it to a person in Europe who would likely have access to free healthcare after his or her retirement. Okay, so to conclude on this point is both a person's labor and his employment, his conditions of employment, as well as his membership of a retirement fund are built on constitutional imperatives. Okay? Due to the principle of subsidiarity, however, you cannot run to the Constitutional Court if you have a problem with your labor relationship, or if you are unhappy or you are negatively affected by anything in terms of your membership of a retirement fund. Nay, the principle of subsidiarity says you have to exhaust your internal remedies first, and don't worry, citizen, I will give you mechanisms where you can refer your disputes to so that you can resolve them without having recourse to the Constitutional Court directly. Now, the relationship between Section 23 of the Labour Relations Act that guarantees, or of the Constitution that guarantees that you will not be subjected to unfair labour practices, has to a great extent been canvassed by our labour courts, labour appeal courts, and even the CCMA. But the relationship between the Labour Relations Act and the socio-economic rights, and here I mean your membership of a retirement fund, has unfortunately not been subjected to vigorous scrutiny by our courts up to now. Okay? Now, you will notice that my slides are very busy, and therefore I want to propose that you rather listen to me today. We will distribute the slides to everyone afterwards, but I personally sometimes find that slides afterwards are too cryptic, and it doesn't give me all the context that I would like, and therefore my slides are busy. So please read them in your own free time. So, as we all know, in South Africa, there is no obligation on retirement funds or on employers, to make a retirement fund available to its employees, right? But those employers who do, and by virtue of you attending the seminar today, you are already in that group of employers who deemed it necessary to provide retirement fund members with retirement benefits. And the reasons for that can be of a multiple nature. It can be to retain and also attract the best talent that is out there available to whatever it is that you as an employer do. It could be because the employer is feeling a moral obligation to provide for its members and their families. That doesn't matter. By virtue of the fact that you did make a retirement fund available to your members and you made membership compulsory in terms of the Income Tax Act, now already tells you that you fall under those constitutional imperatives that I highlighted at the beginning. So as you know by now, South African law was influenced heavily by English law and then also Roman Dutch law. And the principle that crystallized in the UK was that retirement fund membership is actually part and parcel of the employee's remuneration. So you will see in my slides that I quoted two cases there for you: Young Husband versus DECRA contractors, and then secondly, Risa Pension Fund versus Pension Funds Adjudicator. All that you need to remember from these two cases is that a member's membership of a retirement fund is part of his or her remuneration. Some people call it deferred pay, doesn't really matter. Their retirement fund membership is part of their remuneration package. So when we talk about benefits in the labor law space, there can be many variations of these benefits. The first that comes to mind for our purposes is obviously pension fund membership, but there's also medical aid benefits. Some employers give their employees cars. Some employers will have working from home policies as a benefit. Some employers will say every Friday at 2 we'll allow you to knock off and go and start your weekend. Those are benefits, and once those benefits have accrued to employees in terms of the labor law, it then becomes a legal tussle to determine to what extent the employer can interfere in the provisions of these benefits. I'm not going to talk about all the other examples that I mentioned. I just provided those examples for context. We want to focus on what we call the pension promise. So the employer says that I'm going to give you a package of pension benefits. And now remember, even though the individual benefits can vary from fund to fund, it's usually a savings vehicle, first and foremost, so that the member has means to income after he or she retires. But we also give them a underwritten or self-insured death benefit, where we say, if you were to die, then there will be an insured benefit that becomes payable to your family. We'll give you a disability benefit. Now, the value in that is that this employee doesn't have to go to the retail market to go and procure these benefits for him or herself. And then by definition, these benefits are usually cheaper because it's done on a group basis. Now you will recognize that even though you promise these benefits to your employees, it's not usually incorporated into the employment contract itself. Nay, that is something that falls outside the scope typically of what you would incorporate into your employment contract. And I'm not going to spend too much time on this slide because it gets a bit technical, but there are 3 frameworks, and I encourage you, you can go and Google just the words pension promise. You'll come across 2 articles that were written by Graham DeMont and Tasha Jitu that deals with these 3 frameworks in a lot more detail than I intend to do today. And it just explains that the pension promise can either not be incorporated into the employment contract, where the benefits are discretionary and where the employer is allowed to act unilaterally to change those benefits without reference to the rule and only subject to a duty of good faith towards the fund and its employees. And then secondly, the proper exercise of their discretion. And then thirdly, the trustees' duties and obligations in terms of the Pension Funds Act. Or secondly, the pension promise can be fully incorporated into the employment contract, where the employer cannot act unilaterally to change the benefits of members. But you can engage in a negotiation process with your employees if you do want to make changes to those benefits. And then thirdly is a mix between the first 2, and we call that partial incorporation. Now, the reason why you need to understand that the contract of employment can be interpreted in 3 different ways is it influences the way in which you as an employer need to engage your employees about changes to pension benefits. So the complicating factor for an employer and the pension promise is that after you provided and sponsored a retirement fund for its employees, the employer effectively steps back because the pension fund is a separate legal entity there. And the employer loses effective control about how the pension promise is delivered to its employees. In fact, the employer is then merely regarded as a third party with a common law duty of good faith towards the fund and its employees. So that is important to understand. After providing membership, the employer steps back and the pension fund then takes over the delivery of the pension promise. The other complicating factor is, if you look at the definition of a pension benefit in the Pension Funds Act, it only accrues or becomes a right when the member starts claiming a benefit in terms of the rules of the fund. Prior to that, in law, we say that members only have an interest we talk about a pension interest or an expectation. The Latin word is spes. You spell it S-P-E-S, and it means you have a hope of one day receiving a benefit from the fund upon the occurrence of one or more contingencies as outlined in the rules of the fund. Okay? So if members are unhappy about the delivery of the pension benefits, they cannot technically say that they're enforcing a right because they only have an interest at that stage. I've already mentioned to you that the employer loses control about how the benefits are delivered to the employees or the members of the fund. And we need to acknowledge that in the 68 years of the Pension Funds Act now having been in force, that there's very little academic writing about this particular aspect. And where does it become particularly relevant, delegates? Something that is happening in our industry at the moment is, and I'm not saying whether it's a good thing or whether it's a bad thing, but employers are finding it more and more attractive slash productive slash beneficial to change standalone arrangements into umbrella arrangements. Now, the question whether standalone funds are better than umbrella funds is a totally different topic. What we need to look at is, as a member of a standalone fund, members have certain reasonable benefit expectations, which is not defined in the Pension Funds Act, but there are certain interests by virtue of their membership of a standalone fund that is theirs. Now, by moving them into an umbrella fund, those rights or expectations may be affected. And what I'm trying to talk to you about today is, to what extent can the employer unilaterally interfere with regards to the provision of the pension promise to its employees? So I've already spoken to you that the pension law has not actually developed sufficiently. The next and the third point that I wanted to discuss with you is then competing jurisdiction. Please remember that I spoke to you about the principle of subsidiarity, and we've learned already today that both the right not to be subjected to unfair labor practices as well as the right of access to socioeconomic security are enshrined in the Constitution. Even though that is the case, you remember I told you that you cannot approach the Constitutional Court directly when you feel that any one of these two distinct rights have been affected adversely. The principle of subsidiarity says you have other dispute resolution tribunals or the courts that you must refer your disputes to first. Okay. So in our space, the retirement fund landscape, when we look at the intersection between pension law and labor law, you will see that there are three forums, first and foremost, that are available to members, usually at no legal cost, where these types of disputes can be referred to. First of all, it's the pension funds adjudicator. Secondly, it's the labor court and the CCMA. Now, what is important in deciding which forum to approach is to take a decision whether your dispute is about a right that has accrued to you or whether it's about an interest that accrued to you. So in labor law, that distinction is very important to distinguish between a dispute of right versus a dispute of interest. And generally, the pension funds adjudicator is unlikely to entertain a dispute about labor law and labor law principles. They tend to focus more on pension-related issues. But there's one very important distinction, and that is, just as the Office of the Pension Funds Adjudicator started around the turn of the century, 2000, 2001, 2002. Now, for you who are as old as me, you'll remember that was the time when employers were doing large-scale, they transferred defined benefit fund membership to defined contribution fund membership. At the time, the argument was raised by especially collective labor that by changing the fund structure from a defined benefit fund to a defined contribution fund, the employer was effectively changing the conditions of employment. And we see that around that time, the adjudicator did get involved, did get its hands dirty. The very first pension funds adjudicator, Mr. Murphy, I think it was Professor Murphy, he did entertain labor-related issues when he ruled on the transition from defined benefit to defined contribution funds. But in today's context, generally, we should not expect that the adjudicator is likely to get involved in labor disputes. All right? There's something that I'm wondering about, though. Carla spoke to you about the definition of a complaint, and we've learned that it must be about the administration of the fund, it must be about the investment of the fund, or thirdly, about the interpretation of the rules. So if an employee comes and says, I am unhappy, so comes to the adjudicator, therefore, and says, I'm unhappy about the employer's decision to change my pension fund from X to Y, because the outcome of that is that there will be, for argument's sake, a smaller portion of my benefit going towards retirement, or I will only have 2 times annual salary cover for a death benefit versus 3 times annual salary death benefit cover in my current fund. The adjudicator is likely to say, I deem that as a labor dispute, all right? So I do not have jurisdiction. But something interesting happened with the effective date of the Financial Sector Regulation Act on 1 April 2018, where Section 30D2 of the Pension Funds Act was included, which now expressly makes provision for equity jurisdiction. I do not think that giving the adjudicator the right or the statutory powers to entertain a dispute on equity basis automatically renders labor law disputes as disputes that fall within the jurisdiction of the Pension Funds Act. So let's look at a few case law examples, and with this I'm going to conclude. So we saw a very interesting case towards the end of 2023, and it's the matter of Municipal Workers Retirement Fund versus South African Local Government Bargaining Council and others. I'm going to use the abbreviation. You will recognize SALGA, IMATU, and SAMWU as recognized abbreviations of bargaining sector units and stakeholders in the retirement funds that these employees participate in. Now, SALGA entered into a collective agreement in terms of which all the various funds that municipal employees belong to would have to undergo an annual assessment, to establish whether the benefits that were being provided to municipal workers in those individual funds complied with some arbitrary benchmarks. And in the event that those individual funds did not comply with those benchmarks, then those members would be forced to belong to a SALGA-sponsored retirement fund. Okay? Now, to put it in perspective, just off the top of my head, I can think of at least 10 different retirement funds that municipal workers participate in. There's the Municipal Employees Pension Fund. There's the Municipal Councillors Pension Fund. There's the South African Local Authorities Pension Fund. And so the list continues. And what we learned is that collective agreement affected 250,000 employees that are working in the municipal sector and thousands of people who were receiving pensions from these funds. So the Municipal Workers' Retirement Fund took issue with this collective agreement and said that it does not fall within the law, as simple as that. They said that this was now an agreement that was entered into between third parties, unrelated parties, that had dire and material significant impacts on the existing funds, right? And they said that if they were not a party to those negotiations, whatever was negotiated at that forum could not be made enforceable against them. Okay? And they succeeded in convincing the court, and the court ruled that any changes that were negotiated and then recorded in a collective agreement cannot be made enforceable against these 10-odd third-party retirement funds. In other words, there was no way that SALGA could obligate those funds to comply with the proposed annual assessment and then the potential transfer of their members to an additional fund afterwards. I'm running out of time, so I do need to go through this. I've mentioned the principle. Then another interesting issue where we do see where the case law helps us, where the pension law actually informs the labor law, is in those cases where members are dismissed due to having reached retirement age, when the retirement age has not been recorded in a contract of employment. And I've listed there a number of cases where this issue was discussed previously. But the most important one and the most recent one is Investor versus CETA. Please go and read the details of the case in your own good time, where the court said if the employer and the employee did not agree on and record in writing in the conditions of employment, then you can go and have a look at what the rules of your employee's retirement fund or provident fund says about the adequate retirement age. And there are many other case law examples, ladies and gentlemen. When an employer sells its business as a going concern to another employer, and those employees are transferred in terms of Section 197 of the Labor Relations Act, those are typically also instances where the employer has to do certain things based on its common law duty of good faith towards the retirement fund and its members. So I'm going to summarize and conclude with what I think are the takeaways from my presentation today. So retirement fund membership by an employer, even though we acknowledge that it's not a general legal obligation to provide a pension fund to your employees, but when you do, then it becomes a condition of employment and it forms part of the member's remuneration. So employers need to understand to what extent the pension promise has been incorporated in the rules of the fund and the contracts of employment. Okay? So you remember I referred to three different frameworks, either wholly incorporated or not incorporated or at all, or a mix between the two scenarios. Now, there's no dispute that employers have prescribed statutory duties in terms of the pension fund law, and that is to pay contributions, provide minimum information, notify the fund when an employee has died or has become disabled, etc. And this is probably then my sole suggestion for purposes of today. Very few retirement funds have a written service level agreement with the sponsoring or participating employer. Why not go and record both the statutory duties as well as other common law duties that the employer has to comply with, and record it in an agreement between the fund and the employer? You've heard that I referred to the employer's duty of good faith a few times today, and that is a common law duty. And, in my slides, when you get them, you will see that I refer to case law where it's been confirmed by our courts. This duty, for instance, entails not only complying with the statutory requirements of paying contributions, etc., but also when you want to change the benefits, that you can't do it arbitrarily or unilaterally as the employer. You are probably obliged to comply with at least the requirement of due process. In other words, just like you would negotiate the remuneration or the provision of benefits like working from home or a company car or a death benefit in terms of pension fund membership, engage in a process with your employees and negotiate those proposed changes that you as an employer want to introduce, even if it is changing the structure of the retirement fund or even the identity of the retirement fund. And what is important to note here, and with this I'm definitely going to conclude, the outcome of that due process is negotiable, right? Members cannot say that we insist that the outcome of this process must be A, B, C. That they can't do. But what is not negotiable is that the employer follows that process. The outcome remains negotiable. So I did rush through this topic. I think we can spend a bit more time on this, possibly in future legal seminars. If you have any questions, please do not hesitate. You have my email address. You can send them to me, even if you want copies of any of the decisions that I referred to in my presentation today. Thank you very much, Nicole.
Thank you so much, Lee. But yeah, that was quite an intricate topic as well. So we do encourage our attendees to please make sure that you just request the slides and you'll have the opportunity to engage it further. Our next presenter is going to be Tato Dechale. And I've seen already we've gotten some comments and questions regarding his topics. He'll be speaking on the infrastructure and regulation 28. Tato, thank you.
Thank you, Nicole. Welcome to all our delegates online. When I was asked what investment topic would be interesting to talk about at this legal seminar, I thought, given all the conversations that are happening around infrastructure, a lot of it obviously spurred on by trustees coming forward and being concerned about, this concept of prescribed assets. I thought, it would be quite important for us. And we've also seen a plethora of managers, asset managers that are coming out and, putting forward infrastructure or rather unlisted products in the market. So I thought I'd use my 15 to 20 minutes discussing how pension funds can get into the space or invest in the infrastructure space. But just to take a step back before we get there, the biggest thing here, I think why this has become so topical over the last few years has been because of the big emphasis, or rather the big focus that the last changes we got from Regulation 28, which had quite a big emphasis on infrastructure. And so I'll take you through some of that background and some of the recent changes to Reg 28. And maybe just before I talk about that, I'm assuming that everyone on the call understands what Reg 28 is, but just to give you some background, as part of the Pensions Fund Act, we do have a section in the Pensions Fund Law that speaks about how pension funds should go about investing, and that is what's known as Regulation 28. And so essentially it gives you prudential guidelines on how pension funds should go about investing across the various asset classes. So just to give you my agenda, we'll just talk about the background, summary of some of the last changes that we got in Regulation 28, the case for infrastructure investing, I don't think it should go by surprise why there should be a case for investing in infrastructure, but I will cover it in my slides coming up. What we think current positioning should be, or how funds should be thinking of this. And then in closing, I'll just cover, our recommendation and just the way forward for all our clients and prospective clients. If we just started with the law, just to give you some background, back in July of 2022, National Treasury published their final amendments to Regulation 28. As we all should be aware, Reg 28 is a living piece of legislation. We get a lot of changes, or rather ongoing changes in Reg 28, where obviously if there's a new asset class or something that Treasury feels they should come out strong on, you find they will bring those changes to Regulation 28. This was following what I guess government saw was, they wanted to drive the inclusion of retirement funds in plugging that infrastructure gap. As a team, which is ourselves as NBC Investment Consulting Services, we've initiated the process of allocating additional assets to these unlisted investments that target infrastructure investments. Now, just to give you some background, this isn't a new form of investment. As you'd be aware, as back as coming into the new dispensation of the democratic country that we live in now, prescribed assets in the past were actually used for a lot of development by the then government, where they actually did use a lot of pension funds to build the infrastructure that we now enjoy. However, just to caution, I know that there's been a big concern that government is going to get involved in prescribing assets again. And obviously, given that, there's been this break of trust in government legislating anything, I just want to put everyone at ease in that currently it's not in the form of prescribed assets. And so all that Regulation 28 is trying to say, they now have a very specific target at essentially asking funds to be aware of how much exposure they have to infrastructure investments. Now, this slide just talks about why infrastructure, all right? I think it shouldn't go by surprise. These are the biggest headlines on all the local newspapers of how we have such ailing infrastructure and how government is not really getting to all the necessary targets that we need to maintain, both the human dignity of our citizens, but more importantly, for us to be able to grow the economy. The chart on the left I got from Outlier. And I just think it shows you the shocking stats about how much we've lost, how much power we've lost, and the amount of hours that we've lost to load shedding. So in 2023, we lost up to about 6,800 hours to load shedding. And I think what is important to see from the previous year, that's quite a big increase in the number of hours. But also more importantly, if you just look at the severity of it, obviously, more on stage 4 as well as 5, and you can see how the big jump has been in stage 6. And that is obviously one of the biggest impacts to any economy. If you don't have a stable supply of energy in your economy, it's very difficult for all industries to operate optimally. And so for as long as this is a problem, it won't really assist. And so on the right here, you can see a lot of the parastatals have been struggling due to various reasons. Obviously, Eskom, I've spoken to the load shedding hours. We've now seen Transnet come to the forefront in conversation, especially around the fact that our rail services are not working as well in transporting goods from our ports. And so we've got a lot of backlog at the ports because we're relying too much on our roads. And of course, now the roads are deteriorating. A lot of that kind of infrastructure is obviously now heavily burdened, given that we can't rely on trains the way we should be. The latest crisis that we've started to seeing is how water is now going to start to be shedded as well. In all the major cities in the country, we've all been affected by water supply not being constant. And so this slide sort of just encapsulates why infrastructure investing is so important, because government will not get to all these very severe or other important needs and goals that we have to reach and maintain. This is where private sector comes in, or other public players, and like yourselves, right, as pension funds. So what are some of the changes that Reg 28 has come up with, and why are you seeing this big focus on infrastructure? You saw even in the last budget speech from Treasury, the finance minister speaking a lot about infrastructure investing. And the reason is this. So you can see here, Reg 28, as of 2022, they did now say there was at least that infrastructure in pension funds. So pension funds should at least have a 45% allowance to infrastructure investing. And so by at least, they're trying to say, they're trying to encourage funds to obviously do as much as they can. But the fact that for the first time, the regulation is focusing on having a comment on infrastructure is because of that previous slide that I showed you previously. They also did speak about some other interesting asset classes, which we've seen for the first time. There was a comment on crypto assets, where it was rather just defined, but obviously for now it is excluded as an investable asset class for retirement funds. But I think it's been interesting the fact that Treasury made a comment on crypto assets, which is something that was very silent in the past legislation. If you look at the private equities point, there's also been an increased allocation. So we've gone from about 10% in allocation to about 15% for retirement funds. And there again, Treasury is aware that unfortunately, because of how the listed space has performed, so by listed, we talk about the traditional asset classes that we are aware of. Those are usually like the shares that we know that are listed on the JSE, the bonds that are listed on the bond exchange. In essence, government is aware and Treasury is aware that those listed asset classes are not performing particularly well. In fact, they haven't done too well for the last 5 years. In fact, what we've seen is that a lot of the unlisted private equity funds have actually earned very good returns for a lot of the local pension funds. In terms of the hedge fund side, so if you strip out hedge funds outside of the private equity, those have been kept at the maximum allowable, which is the 10%. In terms of infrastructure, the actual definition by Reg 28 is very broad. So in other words, if you just want to keep it simple, it's essentially anything that is built and is physical and you can actually literally see and touch and enables the economy to function, essentially. So anything that facilitates physical mobility of people and products, infrastructural goods that reduce the cost of delivered goods, something that obviously removes productivity constraints, increases competitiveness, and more importantly, creates jobs, right? I mean, a lot of the booms in any economy have been followed by governments having direct spend on infrastructure. And so because we know that government does have a lot of constraints and currently, they have a budget that is quite difficult for them to manage. They have a lot of service costs to deal with. They are not quite getting to the goals that they've set themselves. And so that's why you're seeing this big push and this big emphasis for public funds and private funds like yourselves as pension funds to invest more into the space. And a lot of this will provide access to more growth and a lot of unique opportunities in niche sectors that are not readily available in the listed markets. Why is this such an exciting avenue for pension funds to invest in? Whether it's infrastructure funds, unlisted property funds, some impact funds, those are the big socially responsible funds, private equity funds, some of the unlisted debt funds, is because of the kind of, the returns that they promise to unlock. I know that one of the criticisms that this space gets is the lock-in periods and the lack of liquidity. We are starting to see a lot of innovation come through to try and deal with some of those constraints. But the reality is, unfortunately, because you are looking at an unlisted investment, especially when you're going into the direct infrastructure space that we're speaking about today, is that you can't shy away or you can't get away from some of these onerous lock-ins. And I think the reason there is quite a simple one. If you just think about the kind of investment you're doing here, we're not buying a listed unit on an exchange where we can know the price at any given time. You're essentially buying into a long-term project that has a long-term impact attached to it. But the great thing is that there is a payoff. A lot of these funds are delivering double-digit growth, the kind of returns that you're not seeing in the traditional listed space. And that's because, they fuel growth. They are real assets that you can touch. And in essence, they can generate a lot of potential for many, many funds. I thought it would be important for us, given that we are talking investments, just to look at what does the risk return payoff look like for some of these investments, because I know quite often people perceive these assets to be far more riskier than, say, some of the traditional asset classes. So what I'm sharing with you here is a risk return graph from the Credit Suisse asset management team. And they've done a lot of extensive research around these asset classes. So on the horizontal, here's your expected risk. On your vertical is expected return. And so what you see, what I want you to focus on is this grouping of these of the brown bubble here, as well as the green bubble. And so the brown bubble refers to what we call brownfield infrastructure. And brownfield projects generally are the ones that invest in urban areas where you already have some level of development in the area. You know, government has laid down some of the bulk infrastructure. So essentially, you do expect that the risk, as you can see, is much lower than, say, some of your greenfield projects. Your greenfield projects are the extreme opposite of that, right? So greenfield refers to projects that go and build infrastructure in rural, undeveloped areas. So middle of nowhere, where no one has any dealings, there's very little economic activity. And so that's where the spectrum is on the risk side. And you can see that those tend to be a little bit far right on the risk style. However, they do promise far greater return, which speaks to exactly that, that investment theory that we all know, is that everyone wants to be compensated for any excess unit of risk with that excess unit of return. Now, if you look at some of the projects you do get on the brownfield side, it's all the ones we know of more recently. So, the energy deals, so all your electricity generation type of projects, your gas processing projects, a lot of the ports. And that's because those kind of developments do tend to happen closer to more developed, or rather more urban areas, if you like. Obviously, I mean, ports, if you think about it, they have to be within reach, rail and road. If you look, and then some of the others are some of the things that we should all be aware of. So seasoned toll roads, some social infrastructure, so housing, which is a big one, student housing, student accommodation, which has also been very topical. I mean, a good example of the toll roads has, the toll roads that we got last, that were put up by Sunrail, which obviously we all fought, and they've actually now taken that away from us. But essentially, those are the kind of investments you get in the brownfield space. Now, I think what's important to note is, where do they sit in relation to the traditional asset classes? So your fixed income funds, those are usually your bond type mandates. Those tend to be lower risk compared to these, but you can see that the returns are also not as strong as what you can expect in the brownfield infrastructure funds. On the green side, the greenfield side, and remember, this is where we go out and build bulk infrastructure in rural, areas that are untapped and haven't really been developed much. And you can see the risk down there is very much similar to shares and equities. In some instances, it's going to be definitely a lot higher in terms of the risk, but you can see how attractive some of those returns are. And these are things like, new toll roads, merchant power plants, so much bigger ones, greenfield project developments, anything. There's a lot that falls into these groupings. Now, obviously, in our view, given that the reality of it is, not all funds are sizable enough to play within the space. So obviously, the sizing is quite important. Liquidity becomes an issue. We do not want funds to run into a problem of having too much exposure to these kind of deals. And ideally, as NBC Investment Consulting, we prefer managers or third-party managers that are in the space to rather be looking at some of the more developed investment projects, and not these purely venture capital early stage projects, where we've seen a lot go wrong in that space in the early days. I thought I'd include one of the longest standing funds that we've known of, and this is the Ideas Managed Fund, and it's been around since 1999. And what they do here, it was managed, or is managed, by the Old Mutual Group. And not to say we have any bias at all, I just thought I wanted to show you the long-term history in performance of one of the longest standing funds in that space. And you can see it's that dark green line that you're seeing over here. And what we've done is we plot this graph against the traditional asset classes locally, that be, the listed, the Aussie market, which is the all share, or the equities that are there, You can see it's followed by the light green, which is our bond market. That's the OLB. Next to it is the property market, which is the listed property side. You can see there. And then the straight line or the smooth line at the bottom being money market line. So that's a STEFI index, which shows you how cash has performed. And I think this shows you the big influence, or the clear look through to show you how, these unlisted type funds that take advantage of the infrastructure spend more particularly are actually quite well positioned to stomach some of the the shocks of the market. And over long periods of time, they actually do perform a lot better than our listed traditional assets. What are some of the advantages and obviously disadvantages? This is obviously not a complete list. I mean, I think there's many, there can be many factors that are brought through, but maybe just to touch through some of the bigger ones. So the cash flows from a lot of these kind of infrastructure funds do have a low correlation to any asset class, and that's because of the nature of the fund. They do tend to be far more resilient, even during economic turbulences. And the reality of it is, I think that's a simple one to understand, because you are building infrastructure that, when it's well positioned and is used in the correct way, will generate returns and can actually be good for the growth of the economy, irrespective of whatever economic downturn you're experiencing at the time. You do find that they do over time provide steady returns. It also has delivered, much higher risk-adjusted returns than most asset classes over the long term. And that's because they're not as susceptible as the traditional assets are to the various shocks in the economy. Some of the disadvantages are obviously things like liquidity, which obviously is something you have to really think about as a fund. A lot of the bigger funds enjoy, far more bigger allocations to this asset class. I mean, the likes of GEPF, who, own a lot of infrastructure in the country. And that's because, they're a trillion-sized fund, so they can afford to. So liquidity obviously has to be managed should you get into these. A lot of the issues here is also around valuations of these assets, which you have to try and get on a regular basis. I think this is a very important one. There's a lack of expertise among, private investors to engage in infrastructure projects. I find a lot of the time trustees are quite concerned due to, the lack of understanding of how this asset class works. So a lot of work usually has to be done in training and helping trustees to understand, how this asset class performs, because it's completely different to what we're used to in the listed side or the traditional side. And then, of course, you do have some, strict regulatory thresholds for institutional funds. The level at which you obviously can invest here is guided by Reg 28, and you've seen that allowance go up over time. Now, in terms of the various funds that are out there, we see a lot of managers on a weekly basis that are coming to us to talk about these infrastructure funds, be it private equity funds, unlisted debt, unlisted property. There's many different types. And so one of our biggest goals, or rather one of our biggest goals that we've taken on, or projects that we've taken on for all our clients, is to help them understand how these funds are all different from each other. You have a lot of players now that have come out. Energy was quite a big trend for some time. We've seen quite a few managers come out there. Impact tends to be more diversified, so it can mix all of these asset classes together. You get the unlisted property side, which a lot of funds have taken interest in, the likes of Future Growth and all the community property funds, the likes of the Sanlams, the Patisas, the IH Aces. We've seen a lot of interest there, which takes care of things like student accommodation, affordable housing. Then you have your multi-sector ones that try to group all types. So if you want more of a balanced approach, we do have funds or clients that say they're a bit nervous to choose one sector. Why aren't we taking a more balanced approach? That has also been quite topical amongst our clients. Then you get the pure private equity players. These on the risk style obviously tend to be far more riskier. Is in essence, you as a fund are buying an equity stake in some of these deals. So you're going direct. There's a lot of players in that space who are seasoned that we do DD from time to time. Then, of course, you have the unlisted debt side. These tend to be a bit more lower risk. And essentially here, you as a fund are giving debt to these players, and they go and they invest into some of these deals. Debt tends to be a bit more protective because you can have an agreement with the asset manager, and in there they have to sign up to paying you certain levels of repayments at a certain time, at a certain interest. And then you have obviously the asset that backs it as collateral. What is our current positioning? We've been utilizing some of the longer known, the more experienced portfolios that are out there, with a mix of some of the new developed, the new developments that are coming in, or the new funds. A lot of our funds do have quite big exposure to the community property fund from Future Growth. They also have an infrastructure development fund, bond fund, Future Growth, that is. Future Growth they one of the boutique managers from the old mutual stable. So that team that used to manage that ideas fund that I showed you actually manage a lot of those funds. So they're quite experienced in that space, and we've had quite good experience with them. The likes of Patisa that we've partnered with more recently, the likes of IHS that we've also partnered, that we've also DD'd more recently. I think the important thing for all clients is that in this space, you have to spend a lot of time, kicking the tires with managers. So our due diligence processes don't just stop at the appointment of a manager. It's actually quite ongoing because, things do change quite a lot in the space. And unlike the listed space where we can rely on an exchange that has, an exchange that does have all this information and requires these managers or any investor to do the work, we have to make sure we do it independent of what they tell us. Of course, we keep a database of how these funds have performed. And a lot of it is that we also want to identify the funds that have the capacity to allocate to infrastructure. And obviously, we want to see them move that infrastructure conversation forward. So just in closing, and just the way forward, it is important, I think, for all funds to evaluate the universe of infrastructure funds and update the unlisted investment database on an ongoing basis. It's important that you evaluate the impact of adding unlisted investments to specific funds, given obviously the size and liquidity requirements. This asset class is not something that's viable for all clients. If you have, a smaller fund or a fund that is, doesn't have members who have long terms of employment or can secure long terms of employment, where we're paying out a lot of retrenchments on a regular basis, then you have to really take cognizant of that and be worried to not run into liquidity issues. I think a lot of conversations have to be had, obviously, at investment committee level or even at board level to talk about infrastructure investing. And then, of course, on our side, and even yourselves as trustees, you want to obviously monitor the performance of these funds and any developments that may happen in the infrastructure space. Because in our view, we don't think this asset class is going away. We think it will remain for a long time. If anything, it looks like, the legislation wants to be even more enabling of it. Currently, they're saying at least 45% allocation. Who knows if, at some later stage, they might start to, almost dictate how much funds should have. But I don't think clients should fear the space. We think there's a lot of value to unlock. But of course, it should all be done, within the reasonable measures and obviously within the guidance of the regulation. Thank you. That is it for me.
Thank
Thanks,
you so
Nicole.
much, Tado. Just to our attendees, we will be now moving on to our next speakers. Thank you, Tato, for that. It was quite informative. And just a reminder to all of our attendees that the slides and the recording link will be available to you after the presentation. And also another reminder to just download your CPD certificate after the webinar is closed. We're quite pressed for time, so it doesn't look like we'll have a live Q&A session, but your questions have been noted. Should you wish to still pursue your questions further, please remember that you can always contact any one of the presenters, or you can email nbcwebinar@nbc.co.za. And for now, we will move on to our next presenters, which are Kogetso and Ndabe, who will be co-presenting on the risk management.
Thank you, Nicole. Good day, ladies and gentlemen. I'll be going through the FIC section of this presentation. Now, the Financial Intelligence Center Act 38 of 2001, popularly known as FICA, was actually established to combat financial crimes such as your identity theft, money laundering, your terrorist and proliferation financing activities. Now, in 2017, there was an amendment to this act to ensure that South Africa aligns itself with the global legislation as set out by the Financial Action Task Force. The act is not only limited to prevent or detect the proceeds of criminal activities, it has other powers. And the most important one is the monitoring of financial institutions. This is to ensure that they comply with the regulations. Now, who does FICA actually apply to? It applies to all accountable and reporting institutions. Now, the list of institutions include the financial services providers, which are your administrators, and as well the trustees. Criminals are actually targeting these financial institutions to disguise the proceeds of unlawful activities. That is why we now have a requirement called Know Your Client. As a financial services provider, you are required by FICA to adopt a risk-based approach. This means as an institution, you need to understand how your services can be used for the purpose of terrorist or proliferation financing and how to actually mitigate that risk. It is very important as well to conduct customer due diligence. Know who you are doing business with. And all these customer due diligence records, they need to be kept as prescribed by the Act. On your clients, you need to conduct sanctions screening and also report to FIC when required. The responsibility of FICA compliance lies with your directors, your senior management, and the compliance officers in a legal entity. Very important to note that when you are collecting all this information to ensure that you comply with the FIC Act, there are necessary legal agreements and policies in place for that personal or sensitive information that you are collecting. Now, retirement funds are not accountable institutions as yet. However, they are not exempt from all the other FICA obligations. Section 29 of the FIC Act, which deals with reporting of suspicious and unusual transactions, states that retirement funds will no longer accept blindly all these additional contributions from their members. If members make large lump sum contributions and without disclosing the source of funds, we definitely need to request supporting documents. It could be that members are selling their properties or they are redeeming their investments. But in that case, we do need supporting documents to make sure that we know where the source of funds are. With regards to the stakeholders, it is imperative for the participating employer to identify and verify their employees. Now, the retirement funds, they need to identify the key risk areas and to ensure that they monitor all these for the effectiveness of the controlling systems. They need to conduct customer due diligence on the participating employer. That is very important. And keep all the customer due diligence records. Also, if the need arises, they need to report suspicious and unusual transactions to the regulator. It will make this process more seamless if we utilize the principal officer to collect all the FICA documentation for the participating employer, the retirement fund, and the board of trustees. It will make it easier for the administrator, also known as the financial services provider, to conduct their own due diligence. Now, the FSP or the administrator they have to adopt a risk-based approach. They have to identify, verify the fund, the board of trustees, and the participating employer. They have to conduct the sanction screening and the record keeping of all identification and verification documents. They also have to report to FIC when required. For all actions, there are consequences. In this case, if there is non-compliance, we have what we call an administrative sanction. Now, the regulatory bodies have had to enact stricter regulations and conduct enhanced monitoring on financial institutions. And this is because of the South Africa's grey listing. So the Financial Intelligence Center and other regulatory bodies such as your Financial Sector Conduct Authority, also known as the FSCA, they may impose a penalty on an institution or a person that does not comply with their FIC Act obligations and directives. Now, most common instances of non-compliance, they relate to failure to conduct customer due diligence on your clients, failure to have adequate controls in place in order to mitigate the risks of non-compliance, and also failure to report to the regulatory body. These sanctions are actually based on the extent of the non-compliance, and mitigating factors are also taken into consideration. These may be a caution not to repeat the conduct that leads to non-compliance, directive to take remedial action. Also, the financial services provider, like the administrator, they may lose their license, or there may be restriction or suspension on certain business activities. Now, the financial penalty is a big one, especially for the legal person. It is up to 50 million rand and 10 million rand for a natural person. Serious offenses carry imprisonment up to 15 years or a fine of up to 100 million rand. Please note, the cost of non-compliance is more than financial. Reputational damage when one is caught for such violation is very critical to a business. Thank you so much for your time. I will be handing over to our executive head of risk management to go through the risk management session. Thank you.
Okay. Let me talk about your Jesus. Good day, ladies and gentlemen. I will be taking you through the risk management aspects with regards to the compliance risk in as far as the FIC Act. The biggest risk that you'd face as a fund or as the board of the fund is the compliance risk, which by definition would be the fund's exposure to punitive action, as has been mentioned, which could be fines or imprisonment. And as mentioned already, the three most common instances of non-compliance from a FICA perspective is the failure to conduct customer due diligence on our participating employer, the failure to have adequate controls in place to mitigate the risk of non-compliance, as well as the failure to report. Now, the responsibility in as far as the boards of funds are responsible for conducting the client due diligence on participating employers, more especially on the onboarding phase, and thereafter are responsible for monitoring and reporting suspicious transactions. So what do we mean when we say client due diligence on participating employers? You might want to look at the source of funds. So you, as the board, wouldn't want illicit funds being paid into the fund's bank account, whether it's for contributions. You'd want to know that this is a legit business and their source of funds is actually legit. So the next step in terms of managing that risk, the compliance risk, would be for you to do an assessment of the compliance risk. And in order to assess the compliance risk, you'd need to categorize it into three categories as follows. Firstly, we'd have to look at the legal impact. The trustees would need to understand the FIC legislation and all its compliance requirements, as well as the punitive actions for non-compliance. Trustees would also need to look at the financial impact. So you'd have to identify any financial consequences to the fund or the trustees in instances when non-compliance occurs. And then lastly, there's the reputational impact, which has been mentioned before by my colleague, which is the extent to which the members, participating employers, and the general public's perception of the fund is negatively impacted. And also the confidence and the trust in the fund by its membership and participating employers. So how do we then manage the compliance risk? So the trustees can manage the compliance risk in the following ways. Firstly, it's gaining an understanding of the compliance requirements, as I've said, and also identifying the factors that could cause the fund not to comply, as well as putting in place mitigating actions and controls thereon to ensure that the fund actually complies fully. And then secondly, it's clearly defining the responsibilities in as far as compliance with FICA and managing the compliance risk. So we have to ensure that the responsibilities are adequately assigned, whether it's to service providers or members within the board. So as my colleague has mentioned, the principal officer could assist in actually gathering information in as far as KYC with regards to the trustees on the board, as well as with regards to the participating employer. They can do this in collaboration with the fund consultant, and also to ensure that the client due diligence is actually done. You know, as I said earlier, in terms of onboarding or the new participating employers, that the relevant FICA documentation is requested from the participating employer and kept on record. And also as well that trustees send in their FICA documentation to the relevant service provider in a timely manner. The fund can also have a FICA compliance policy in place. We all know about PF 130 and good governance. That would be a good policy to have because it will then detail the processes and procedures that the fund is actually going to implement or has in place in order to ensure that the fund is compliant, including how the reporting of any suspicious transactions will be done by the fund and by whom it will be done by. Then the compliance risk should also be included in the fund's risk register to ensure that there is ongoing monitoring of the risk and the effectiveness of the mitigating actions or controls that the fund puts in place. This also comes as an added advantage wherein if the regulator comes to do a site visit of the fund, they then can see through your risk register that as the board, you've actually applied yourselves into identifying any compliance risks, especially in as far as FIC, and ensuring that you do have the mitigating actions and controls. And in your risk register, you will also identify who is responsible for each of the mitigating actions or controls, whether it's members of the board or service providers. In certain instances, the fund can also consider engaging the services of an external expert, where ensuring compliance may be considered to be a complex exercise by the trustees. So we're looking at industry funds that have got lots of employers. You can engage with your fund consultants, any one of your service providers that would be in a position to actually assist the fund in gathering that information. And just in closing, it's just to highlight to the trustees, as my colleague mentioned, South Africa was grey listed by an organization called the Financial Action Task Force. Basically, we were found to be lacking in as far as the monitoring, our anti-money laundering monitoring, as well as management. And there's two key things that came out of that was that one, South Africa is not fully utilizing the tools that are provided by the Financial Intelligence Center. Secondly, that South Africa needed to do better in terms of applying the risk-based approach that my colleague referred to earlier. And this aspect of risk management actually speaks to that risk-based approach. So with the grey listing, the regulators are actually going to be stricter in terms of monitoring. There's 22 recommendations that they're left to implement, of which they were given between January 2024 and January 2025 to implement. Some of the recommendations or shortcomings were that there isn't enough prosecution in terms of people who are involved in state capture. You may have seen in media reports over the weekend that already the NPA is looking to actually arrest almost 90 people that were involved in state capture. So that just goes to show how serious the regulatory authorities, the prosecuting authorities are actually going to be looking at FIC. And they're looking at also empowering the monitoring division with more resources. We are aware as well that FISCA is also now involved in terms of the monitoring under the phase supervision unit. So it is quite critical that this risk is managed and for the funds to avoid any non-compliance. Thank you very much.
Thank you so much to Koketsa and Dabezintle. That one was very nice and short and sweet. We have run out of time, but we are going to be allowing a few questions to come through. So I'll have everyone from the presentation side just on the screen so that we can take a few questions. Then I think we'll have Mr. Liep van Zyl just
Thank you, Nicole. I think we'll have to handpick the questions, but I do think that the questions that we are going to tackle is going to help you. Most of them, surprisingly, are related to the two-pot reforms. I think the first one for you, Tony, and let's try to keep our answers short and sweet, colleagues. By when should funds submit their two-pot rule amendments, Tony?
Liep, FISCA want us to have the template approved first. They've said we can start submitting from May and that they'll need until the end of June to review and agree to the format. So we can then start submitting our draft rule amendments for their approval by the 1st of July.
Okay, so that's around the corner, eh? The work now starts.
Yes.
The second question is, can a member decide not to take part in the two-pot changes? And it's related to another question further down that says, will fees be applied to members who will not be participating in the two-pot withdrawals? Kia, Nicole, do you want to tackle that one?
Thank you, Liep. So essentially, all members are obligated to join the two-part retirement system. What they can opt to do once they are in that system is to just transfer their savings in the savings component into their retirement component. That way they can make use or take advantage of the interest that is gained on that specific money asset.
With one important exception, Kia, if I can add, sorry, Nicole, members over 55 or members who were older than 55 on 21 March 2021, they may decide to opt in or they must exercise an election within 12 months, whether they want to take part in the two-pot regime or not. But generally, for the majority of our members, they will not have a decision to opt in or out. Nicole?
I think you had the second part of the question was regarding the administration fee.
Yes.
So right now, the industry is looking at charging a once-off fee when you make a withdrawal as a member. But the numbers right now, we don't have those numbers, but there will be some kind of administration fee that will be charged to a member alongside their tax when they decide to withdraw from the savings component.
Tony, did you want to add something?
I think the question I was interested in was someone who earns less than the tax threshold. And the answer that I was given is that a person of that income will be taxed on the minimum PAYE rate, which I'm not a numbers person, but I think it's something like 18%.
Yeah. So I think this. Thank you for that, Tony. That is indeed correct. So let's pause a bit on the taxation issues, because what I'm going to mention next speaks directly to managing our members' expectations. And I want to illustrate by means of a practical example what the impact of tax is going to be. So let's have two fictitious people, both of them having 30,000 Rand into their savings component on 1 September 2024. In other words, the maximum that a member can withdraw. Okay? But let's say that one person earns less than 237,000 Rand per annum. In other words, the lowest tax bracket of 18%. The second person earns more than 1.5 million roughly, which is the top income tax bracket, where that person pays 46% personal income tax. This is the practical difference between those two persons. The person who withdraws 30,000 Rand, who earns less than 237,000 Rand, will be liable for income tax at 18%, which is 5,400 Rand. So that person will receive 30,000 minus 5,400 Rand income tax, minus the transactional cost for processing that claim. The second person, who earns more than 1.5 million per annum and pays 46% tax, will pay 13,800 Rand tax. In other words, that person will receive 30,000 minus 13,800 minus the transactional cost. So what I'm trying to illustrate is that the marginal tax will bring about significant differences for different members. And this is something that we must make sure that we communicate to our members so that we manage their expectations appropriately. And then just the last remark on tax, I think the threshold under which people do not pay as you earn is around about 95,000 Rand. Those people do not pay tax. All right. Let's go to the next one. Okay, Tato, I think this one is for you. How will the savings component be invested in comparison to the retirement component? Surely the investment strategy should not be the same.
Thanks, Lieb. Maybe just before I cover this, we did spend quite a bit of time on this at the last legal seminar, just looking at what the investment impact, or rather how funds will be affected, or the investments of the fund will be affected by the new regime. But just to answer this again in a simple way, number one, to answer the second part, yes, your investment strategy will change. And how it will change is that obviously we now have to make accommodation for essentially there's three pots. So you have your current existing assets, you have this, and then you have these two new pots. So your savings pot has to be fairly liquid. And the way we see this working out is that in the first 2 years, I think a lot of members will want to exercise this option just out of the pure excitement of having assets, access to some of the assets. So we have to keep that part of the investments fairly liquid. And it may inform that it's a cash-like portfolio with some pickup. So maybe a fixed income fund that is purely, that's quite fairly, liquid. So we will avoid what I was speaking about today for that kind of savings pot as an underpin. Today I was talking more about long-term investments, and those will fall more in your current existing vested, the vested assets. And then your retirement pot, that one, obviously, because that's long-term and you don't have access to that until you retire, that one can be long-term in its outlook. And so that can take advantage of all the various asset classes and has no limitations. Whereas the savings pot, it has to be fairly liquid, because at any given time, members will be coming to withdraw from it. We expect that the first few years, a lot of members will be aware of it. After a while, we'll obviously engage with every client, but I do suspect that people actually go on to forget about this. And so we don't want the fund to experience a cash drag over long periods of time. And so it will be a client by client case. I do think at some point you might be able to, dial up the risk somewhat, but obviously we have to make those assets or that underpin of that investment to be quite liquid.
So related to that, Tato, while you're talking about that, a question further down, will funds now have to amend their investment strategies from 1 September 2024 to accommodate these changes? Yeah,
the short answer is yes. So we have been having conversations with all our clients to tell them how your investment policy will obviously have to be amended to speak to this. And more importantly, your investment strategy also then has to speak to this. So the short answer is yes. All investment related matters are definitely going to be amended to address this new regime.
Okay, and I think that the last question that we have time for today, and I think this one is for you, Kia. Just want to get it. It's a great question. It sounds like, so it's not really posed as a question, but it reads as follows. It sounds like members with Section 30C deductions should not expect to receive their savings withdrawal benefits immediately. Would you say that that is accurate, Kia? How do we manage?
Yes, I would say that is accurate. Sorry, Leave. Yes, I would definitely. Just to keep things short, because we're running out of time, the structures that the fund has to implement to ensure that there is liquidity with regards to Section 37D deductions are quite stringent. So there are more steps that have to be taken by the fund to ensure that there's liquidity before allowing a member to withdraw from their savings component. So yes, it won't be an immediate access to their savings component.
Thank you very much. That is unfortunately all we have time for. Thank you, Shweta. Nicole, will you close for us, please?
Sure thing. Okay, so thank you, everyone, and thank you to all our presenters as well. Thank you to everyone who posed their questions. Unfortunately, we didn't get time to get to all of them, but as I mentioned, you can email the presenters or you can actually email NBC Webinar at nbc.co.za. Please don't forget, now that we're closing, you can actually download your CPD certificate. It will not be made available to you at a later stage from anyone, so please ensure that you download that now. And then lastly, if you can also just fill in the survey that provides us with any feedback that you have, anything that you liked or anything that you would like for us to add in future so that we can make sure that we are constantly improving this form of engagement. So thank you. We hope that you enjoy the rest of your day, and goodbye.
dream.